Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Tuesday, August 20th, 2024 at 8:31 a.m. For 2023, 3106 DC, Saranda Smith versus Devin Daniel. Attorney Brian Hilderly is for the defendant.
Good morning to everyone.
Your Honor.
We had previously been in court on April 4, 2024, at which time the parties did give their openings, and then we did realize at that time that there was a CPS involvement, and we adjourned the trial at that time to today's date. Ms. Smith, are you ready to proceed?
Yes.
Okay. Mr. Hilderly?
Yes, Your Honor.
Okay. I will give you, because it's been such length of time, I'll give you an opportunity again if you wish to make an opening statement. Ms. Smith, do you wish to make an opening statement or waive your opening statement?
Only opening statement I have is I am still going for full custody or joint custody and week on, week off.
Okay. Elderly, you wish to make an opening statement, reserve your opening statement, waive your opening statement?
I would make an opening statement, Your Honor.
Okay, go ahead.
Thank you. Just to bring the court up to speed on where we are currently, the children have been living exclusively with my client since July of last year. Currently, there is a safety plan in place, placing the children with my client. That safety plan runs through April of next year. And Ms. Smith is exercising supervised parenting time one time per week, facilitated by CPS. We are going to ask the court to grant my client sole legal and physical custody and maintain the supervised visits as they are currently occurring. So it's, as I said, there's still a safety plan.
Closed out.
Still a safety plan in place, and we think that under the circumstances, it's appropriate.
Okay, thank you. Ms. Smith, you can present your evidence at this time. Do you wish to make, do you have witnesses? Do you wish to testify? You can proceed, ma'am.
There is no case open at this time. There is no supervised visitations even available at this time because that case was closed out. There is nothing holding it.
Ma'am, this would be a statement. If you're going to present.
That is a statement. The statement.
Hold on. If you're going to present evidence or a statement, you have to be sworn in, because anything you say and you're not sworn in is not evidence.
That's it. Not swear yourself in either.
So do you wish to be sworn in and then testify, ma'am?
Yep.
Oh, yes?
Yes.
Okay. We'll have you raise your right hand and be sworn in.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay, go ahead, ma'am.
There is no case against me right now, CPS wise. That's closed out. There is no supervised visitations even available. That case was closed out. That is why we have this going on again with trial, because there's nothing in place for the kids right now. Neither one of us have any rights.
Okay. Okay, do you wish to present any other testimony, ma'am?
I have documentation from workers, but like I called because I didn't get none of this documentation until Friday, because Friday is when they officially said that the case was going to be closed out, that they were going to stop the supervised visitations because I requested those until this court date so that me and the kids could see each other without Devin keeping them from me. And they gave me this big packet of paperwork, but I did call yesterday and tried to talk to, I think it was Crystal, which is the judge's assistant or whatever, but she told me that I would have to talk to the judge and see if the judge wanted me to be able to submit this somehow to him.
Okay. Well, name is Christy, and what happens, if you recall, the court did have under the case scheduling order a time for the disclosure of exhibits and witnesses in this particular matter. And those were to
Things
occur
that I got
within,
after that.
ma'am, don't interrupt me when I'm talking. Those were to occur within 21 days of the mediation in this matter. The mediation was back on February 28, 2024. And again, if you did not have exhibits at that time, you could have simply disclosed which ones you were going to use. And obviously, in this instance, the court could have taken that into consideration, but you did nothing apparently until today's date, other than maybe calling yesterday. So court is not
Well,
going to let delinquent deficient exhibits in that were not properly disclosed. So any other testimony, ma'am, any other witnesses or any other evidence that you wish to present?
This was from the CPS case getting closed out, which is why I was not able to turn it in 21 days after that mediation. Because again, the CPS case took place after that. This was all from the visitations with the CPS case that I had going on until they got closed out.
Okay, understandable, but
That's
there's a process. There's a process. You could have filed a motion seeking to submit those exhibits late.
I didn't get these until Friday.
Ma'am, you could have filed it at any point after CPS was involved, saying CPS is now involved. They will have a report at some time in the future. Want to have the ability to submit those at a later date, and the court could have granted it at that particular time. But I'm not going to do it at the time on the day of trial. So anything else, ma'am, that you have to present?
No, just the fact that there's no case against me right now. There's no
Oh.
rights in order with the kids right now.
Okay. Mr. Hilderly, do you have any cross-examination of the plaintiff?
Yes, thank you, Your Honor, just briefly.
Go ahead.
Ms. Smith, where have the children been living since July of 2023?
Since Devin Daniel took them out of my apartment to not have to be charged child support, they've been with him, and I've been fighting to get them back. Legally wise.
And you had indicated that you were exercising supervised visits here recently.
I requested those recently so that we could still, or so that I could still see the kids until this court date, because I knew he would not allow me to. He's been trying to keep them from me, so that's
Okay.
where we're at with this.
And where have the visits occurred?
My dad's house.
And that was something that was facilitated by CPS?
No, that was facilitated by me.
Well, I'm saying you contacted Mr. Daniel and arranged for that?
No, I contacted a family worker. She contacted Brian to ask to keep my case open for the period of time to be able to do those visitations.
So it was made possible through CPS?
Yes, correct.
Okay.
Was that requested?
And when did those visits start?
Those started probably about a week or two after CPS got involved.
So CPS got involved in March of this year, am I correct in that?
A little bit after March.
Okay. So approximately April of this year, the visits started, the supervised visits?
Yeah.
And were those visits on a specific day and at a specific time, or were they arranged? How did that work?
Devin Daniel uncooperatively was not cooperating with visitations. He kept changing them, kept changing the times, and I kept making excuses to why he could not do the visitations. So they have been on and off if I get to see them or not.
Okay. My understanding is they were once a week?
They were not really once a week. Yet again, he kept changing them and then would say there was issues, and then he would make it to where I didn't see them for a whole week, and I wouldn't see them again until the next week. So
how many supervised visits approximately have you had?
Approximately, it's been about 10 or 12. Or a little
10.
bit lower than that. Paperwork wise, I think I counted about 9 or 10.
Okay. And how long do the visits last?
They're supposed to last for 2 hours.
Prior to these supervised visits occurring, were you having visits with the kids?
I was asking to see the kids because he had them at the house and was not handing them back over legally. So while I was trying to do this court process, I was working with him and trying to see the kids until he didn't get nothing sexual from me anymore, and then that stopped. That would be the day that I left with Queen out of his house too, because he wanted to touch me and poke me playfully.
And you're referring this, when you say you left the apartment with Queen, you're referring to this incident that
Right when CPS got involved.
right?
Yeah.
And as part of that CPS involvement, there was a safety plan put in place, correct?
There was a safety plan put in place for why they were involved. That safety plan came out of place the second that they canceled out my case.
So in your mind, with the case being closed, you don't believe there's a current safety plan?
There is no current safety plan. Brian's CPS worker has already stated that to me when he closed out my case.
Okay. Thank you, Judge. That's all I have.
Okay, thank you. Ma'am, is there anything else as a result of that cross-examination that you wish to testify to?
Not really. I'm not allowed to have an attorney on this one because I was not the defendant, so I don't have much.
Ma'am, do you have any other witnesses or evidence that you wish to present?
I had the evidence I had sent in after that mediation, the 21 days, and that's it. But I sent that in through Gmail. I don't know who got that or if anybody got that.
Ma'am, do you rest your case then?
I'm still a little confused, to be honest, because from what I know, this trial was supposed to be for the custody to be placed or for not to be placed.
Okay. And what's the confusion?
It's confusing because I'm not allowed to have an attorney, which is a little confusing because how am I supposed to represent myself and go against him if I'm not allowed to have an attorney to be able to represent evidence to bring to court?
Okay. Well, ma'am,
I'm
in
literally
these-
new to all this, so.
In these cases, the court does not appoint attorneys, so you have to acquire your own attorney or you have to represent yourself.
Yes, but when I requested an attorney, they said I could not because I wasn't the defendant in this case.
Well, doesn't matter, you can't, it wouldn't matter if you're the defendant or plaintiff. We do not assign and appoint attorneys in these matters, so you wouldn't have gotten it regardless if you were plaintiff or defendant.
Yeah.
Well, it sounds like you have nothing more to present then, ma'am?
No, not today.
Okay. Mr. Hilderly, you can proceed with your case.
Thank you, Your Honor. I will call Devin Daniel.
Okay, Mr. Daniels, we'll have you raise your right hand and be sworn in, and then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Go ahead, Mr. Hilderly.
Thank you, Your Honor. Mr. Daniel, where do you reside?
128 Gardenia Street, Battle Creek, Michigan.
And how long have you lived there?
Approximately 3 years now, sir. Or close to 3 years.
And is that an apartment and a house?
It's a house, sir.
And do you own that house?
No, I share it with my mother.
And who resides at that house with you?
Myself, my 3 children, and my mother.
And can you let us know the 3 kids' names and ages, please?
Yes, sir. Devin Lamar Daniel Jr., Queen Lachelle Daniel, Davion Lennox Smith, ages 5, 4, and 1.
Okay, so Devin Jr. is the oldest,
Yes,
and then Queen is,
the middle
4,
child, sir. Yes, sir.
and Davion is 1.
Yes, sir.
And how many bedrooms do you have at your residence?
We have 3 bedrooms.
What are the sleeping arrangements?
And Devin and Queen are sharing a room until I until I switch the bedrooms around here in the next like week or so. And then Davion and Devin will be sharing a room, and Queen will have her own room again.
And are you employed?
Yes, I am.
Where are you employed?
T-Mobile, sir.
How long have you worked there?
I've worked with T-Mobile for closing out 5 months now, sir.
And through that employment, do you have the ability to provide for the kids financially?
Yes,
What's your position at T-Mobile?
I'm a mobile expert, sir.
And what days of the week do you work?
I work Mondays, Tuesdays. I'm off Wednesdays. I work Thursdays and Fridays. I'm off Saturdays, and I work Sundays.
And do you have a normal work schedule in terms of your hours, or does that vary?
No, it's a pretty set schedule.
And what are the hours that you work?
I work 9:30 to 4.
And during the time that you're at work, who provides care for the children?
Junior's been hanging out with his grandmother during the summer, but up until the beginning of this month, he was in a summer program for school. Davion and Queen go to daycare. Davion will continue in daycare, and Queen has a slot for New Harvest preschool that should start sometime later this fall.
And is Devin Jr. going to be starting kindergarten?
Devin Jr. is already in school, so he'll be returning to school this year.
And what grade?
He will be repeating kindergarten. He's not emotionally ready for first grade yet.
In what school is he?
He goes to, excuse me?
I just let my voice trail off. What school is he attending?
He goes to Dudley Elementary.
Is that where he went last year?
Yes, sir.
Has he started yet?
No, school starts Wednesday the 21st this week.
So tomorrow.
Yes, sir.
And what is the nature of the preschool program that Queen's going to be going to? Is it educational as well as providing, daycare, or what's the nature of that program?
Yes, sir. It's billed as one of the elite preschools here in town. So it's both educational and provides that daycare component.
Do you have any mental or physical disabilities that would interfere with your ability to provide care for the children?
No, sir.
Do you have any criminal convictions?
No, sir.
Do you regularly attend church with the children?
No, I do not attend church, but they have been exposed to church. And if they would like to continue to go to church, their Nana goes very regularly, and she has taken them with her on occasion.
What has been the arrangement in terms of custody of the children over the past year or so?
As far as Davion and Queen goes, there has been no arranged custody agreement. That's why we're here. As far as Devin Jr. goes, I have full legal custody of Devin Jr.
Who have they been residing with?
All three children have been staying with me.
And when did that start?
Queen and Davion were brought to live with me on July the 15th, 2023.
And what were the circumstances surrounding that?
The circumstances surrounding that event, sir, the home in which the children were residing, my newborn son at that time and my 2-year-old daughter at that time, was very nasty. It was not a savory environment for children to grow up. There were liquor bottles everywhere, animal feces, and a lot of animals were in that apartment. It was not a healthy situation to raise children in.
Do you have available what we've marked as Exhibit A?
Yes, sir.
Your Honor, we supplied an Exhibit A, which is a series of photographs.
Okay, they were not supplied to us in paper copy, and you provided those to the plaintiff?
Yes, Your Honor.
Okay. Ms. Smith, did you receive those exhibits?
Yes, Your Honor, I did, and that's when I sent my exhibits into.
Okay.
We did mail hard copies into the court at the same time that we also provided electronic copies.
Okay, we will try to locate those. The clerk hadn't provided them to us, so.
Okay. I do have it available. I could send it to Christy right now as well, if that helps, or.
That's fine. Yes, if you could do that, that would help.
Okay, I just sent that out. I guess we can just do some of the foundational stuff while that's going. Mr. Daniel, are you able to look at Exhibit A?
Yes, sir.
And this is a series of photographs, correct?
Yes, sir.
And what do the photographs depict?
This is a series of photos that depict the apartment as it stood July the 15th, 2023, the morning the children and I left.
And these photos were taken by you?
Yes, sir.
And this is an accurate depiction of the condition of the apartment?
Yes, sir.
And who was living at the apartment at this time?
At this time, it was Saranda and Queen and Davion and whoever else she would let flitter in and out of the apartment at that time.
Like,
I'm
it was
sorry. I didn't hear.
at that time. They were living with me too at that time after I had.
Ma'am, this is not your time to talk. You have a chance to question the defendant after the examination is done.
And it was at this time that you removed the children and brought them to live with you?
Yes.
Okay, Your Honor, I did say those had sent. I am going to ask for the admission of those exhibits, or of that exhibit, which is a collection of photographs.
Okay. Ms. Smith, do you have any response to the offer of Exhibit A?
Those exhibits were taken after I was incarcerated, but go ahead.
Okay. Court will admit defendant's Exhibit A, there being no objection.
Thank you, Your Honor. I guess, Mr. Daniel, do you know why Ms. Smith was incarcerated at that time?
She was not incarcerated the morning those pictures were taken.
They weren't taken that
What?
one.
Was she incarcerated around that time?
No, sir, she was not incarcerated around that time.
Okay. So after July 15th, did Ms. Smith have any sort of regular visitation with the children?
After July 15th, between ourselves, she was having visits on Tuesdays. She was having visits on Mondays and Tuesdays.
And where I'm sorry, go ahead.
I'm sorry, grandfather clock's going off.
Where would those visits occur?
Those visits would occur at 128 Gardenia Street.
And so she would come over and visit with the kids at your home?
Yes, sir. Yes, sir.
In approximately how long did those visits last?
They would last from about 6 to 6:30 to 8, right about when I start getting the children ready for bed.
And is that the schedule that you guys followed essentially up
Yes.
until CPS matter?
Yes, that was a schedule that we followed right up until CPS was involved.
And during this time, Davion was in kindergarten?
Junior was in kindergarten.
I'm sorry, Devin Jr. Yeah, I apologize.
Yes,
Was
sir.
and was that something he was going to every day?
Yes.
And how did he get to school every day?
Junior rides the bus to school.
Okay. And then what about he rides the bus home as well?
Yes, sir.
Did he have parent-teacher conferences during the school year?
Yes.
Did you attend those?
Yes.
Did he have any other school events?
Yes, he did have other school events. There was muffins with dads. There was a math program that we showed up to early one morning. We've done some things at school.
Okay, and you participated in those things?
Yes.
I'd like to take you to this incident that led to CPS's involvement. My understanding is that it happened on or about March 12th of 2024.
Yes, sir.
And can you let us know what happened that day?
Well, the whole issue starts about March the 11th. Saranda, which would have been a Monday, Saranda came over for her visit with the children. My daughter went to the bathroom to go change herself. She came back and didn't put her leggings on, and Saranda saw some bruises on her upper thighs, and she claimed that they looked like thumbprints. And that was right before we were getting ready to go to court the first time. So she went home and made calls to Central Intake, had CPS investigating me at my home the very next day. That Tuesday, after the investigation, Saranda shows up for a visit. Her visit starts off normal. She's sitting over on the couch on her phone the entire time, talking with somebody, claiming that she's trying to get her vehicle fixed, this, that, and the other. My mother goes to the store. Her visit starts to run a little bit late, which, okay, my daughter's laying on her mother. It's all right. They're spending some time together. I hear some rustling at the front door, at the porch, and I assume that it's my mother coming home from the store. I go to open the screen door, and Saranda's current baby daddy is on my porch telling me how they're leaving with my daughter. I exit the home in response to Saranda running out the door with Queen and her baby daddy being there. Another gentleman who was outside of the home at the time was also there. Mr. Cole looks back at me and asks me very pointedly, do I want to get shot? I continue to advance forward saying, I need my daughter. And then he looks back at his partner and he says, grab the gun. At that point in time, I turned around and went back inside to grab my phone and started making phone calls to the appropriate authorities in Central Intake.
And what happened with regards to Queen?
At that point in time, Queen was spirited away by her mother. A day and a half later, she was. Yes, sir.
Did you make any observations as to Queen's reaction to this?
Yes, Queen screamed as her mother ran from the house.
Do you have available the video in front of you that we've marked as Exhibit B?
I do.
Your Honor, I did send this over previously, and then this morning I emailed a file to Christy that would provide a direct link to the video. It's proposed Exhibit B.
Okay,
Mr. Daniel, do you have the ability to review that video?
Yes, I do.
We'll go ahead and do that, and then I'll have a couple questions for you just to authenticate the video.
Okay.
Jeff, try sharing our screen. I could try that.
okay.
So we can all see
See if
it.
you can. Mr. Hilderly, we're gonna bring it up so we can apparently do a screen share and everybody can see it.
I'm gonna.
Oh,
Or we're gonna try
We
to,
don't,
let's
we
say.
don't do this very often, so. Yeah, are you able to see that?
Yep,
Yes.
Go full screen, please. Hold on. I'm assuming there's no sound here, right?
that's
No,
correct.
there's supposed to be sound.
Oh, there is. I apologize.
Let me see. I don't know if the sharing will play back a sound, so we may just have like footage. You want me to play it now?
yeah, go ahead.
Okay, it's 30 seconds.
Turn it up too.
That's,
Okay.
yeah. That's it. I can stop sharing now.
Okay,
Mr. Daniel, having reviewed that, is that an accurate depiction of the events?
Yes, sir.
And this video was taken by your Ring camera on your door?
Yes, sir.
Your Honor, I would ask for the admission of Exhibit B.
okay. Ms. Smith, any response to the exhibit
I believe that exhibit shouldn't be allowed in this court case
and why?
because I was told that you guys could not do that video in this court case. That is what I was told before this.
Okay,
That
well,
would be held against me in this court case because I had nothing to do with what he did.
okay. Well, the defendant has laid the foundation, said it's accurate depiction, and he has explained again what had happened. Court believes that it is appropriate, and the court will admit the exhibit over the objection.
Thank you, Your Honor. Mr. Daniel, what happened after Miss Smith left with Queen?
After Miss Smith left with Queen, she was found a day and a half later by CPS during the continuation of their investigation at her father's house, where my daughter was found. At that point in time, CPS did their investigation, asked Surrender the questions that they were going to ask. She admitted to asking her boyfriend, baby daddy, or however you have it, to show up to the house and, in her terms, bring a sledgehammer to facilitate the actions that you saw on the video.
Was Queen returned to you?
Yes, she was returned.
And when did that occur?
That occurred that occurred right after they concluded their investigation at Suranda's house, well, her father's house, the day and a half period after the video was taken. I was at work when she was returned. My mother went to pick her up for me.
You heard Miss Smith talk about the supervised visits. Do you recall approximately when those began?
I cannot remember the exact date, but they occurred shortly after CPS became involved.
How did they come about? Did someone from CPS contact you?
What it was is that I had been talking with Brian, and
Excuse me,
I did. Yes,
Brian
sir.
is.
Brian is my CPS worker, my ongoing worker.
Go ahead.
I had been talking with Brian, and I explained to him how I was no longer comfortable supervising the visits between Surrender and the children. And with that, they started looking at options to provide a supervised visit, which they started doing. The visitation coach was Miss Ari Smith. And while the visits should have taken place on a very, very regular schedule, Miss Ari's schedule between school and her being sick was always changing, which allowed the visits not to be scheduled at a regular time, which needed to continue out and make everybody's schedule very satisfied. The dates kept jumping back and forth and going one way and the next based on Ari's schedule.
Okay. And these visits occurred at Miss Smith's dad's house?
As far as I know, yes, that's where they occurred.
And the supervision was supplied by Ari or Miss Smith's dad?
No, the supervision was provided by Miss Ari Smith.
Miss Ari Smith. Okay. And she works for CPS?
I would assume so, sir.
Okay. And how did the kids get over to Miss Smith's dad's house?
They were transported by Miss Ari Smith from daycare to the visitation place.
Do you recall approximately how many visits there were?
No, sir, I do not.
Do you recall when the last one was?
The last one was last week, sir. It was Thursday.
Can you describe to the court the relationship you have with the children?
We have a very good relationship. All three children have their wants and needs from dad, and they're met. Junior likes to hang out and play with dad. He likes to wrestle a lot. Davion just loves being with dad. He's a dad's boy. And Queen, it took her a while to warm up to dad because of the fact that she's been with her mother for a while, but Queen tends to just, spend a lot of time with dad. She wants to be held. She wants to watch TV. She wants to, she just wants to do things that little girls do with their dad.
And what sort of stuff do you guys do together?
Very recently, we went out to John Ball Zoo. We like to get out and do things that we like to get out and be in the fresh air. We like to go hang out, have fun at the park when we can. But right now, between work and getting everything else squared away in life, very little has actually happened for us to get out this summer and do the things that I wanted to do.
When since the children have been in your care, are you the person that's providing that care? Are you getting them ready for bed, bathing, assisting with bathing, that kind of thing?
Yes.
And do you guys have a regular routine?
Yes, we do.
And just kind of give us an idea of what that routine is.
I get off work about 4:30. I come home. By that time, Junior's already at home if he's at school or in his summer program. I pick Davion and Queen up at 5 o'clock from daycare, and we go about our regular routine at home. We feed the children. We're getting ready for bed about 8 o'clock, 9 o'clock, depending on the night. Showers, baths, just regular routine of schedule for, raising children.
And while Devin was in school last year, were you able to help him with, I know it's just kindergarten, so probably
Mhm.
not a lot of homework yet, but you were able to participate in his schooling and help with anything that he had?
Yes, I was.
And I know they're young. Do any of them do anything like extracurricular activities?
Not at the moment. Not at the moment.
And you've been providing for the children financially,
Yes, sir.
purchasing clothes, food, anything they need?
Yes, sir.
Do the children go for yearly checkups at the doctor?
Yes.
And who scheduled those visits?
I have.
And have you taken them?
Yes, I have.
Uh,
Unfortunately,
go ahead.
because of the situation with CPS, I've had to show up to their doctor early, so they haven't had their regularly scheduled visits. They had CPS prompted investigation visits, so that's
Nice.
that.
How about the dentist? Do they regularly attend dental appointments?
Hmm.
Yes.
Yes, sir. I have to schedule a dental appointment for Queen here soon.
And you said you made arrangements for childcare while you're at work for um, Davion.
Yes, Davion, Queen, and Devin are all cared for while I'm at work.
And then, so this coming year, Devin Jr. will be in kindergarten, and is that 5 days a week
Yes, sir.
for the full day?
Yes, sir.
And then what about Queen's preschool program?
It will be an all day program also.
And is it Monday through Friday?
Yes, sir.
And then you said Davion's going to go to daycare.
Yep, Davion will continue at his current daycare.
You indicated that you have lived at your current residence for approximately 3 years,
Coming up, yes, sir.
and the children have lived with you there at that residence since July of last year.
Davion and Queen have. Junior's been with me here the entire time.
So prior to July of last year, um, so Davion's essentially lived with you his whole life.
Yes.
Did I say Davion again?
Yes, sir. You said Davion. But yes, Junior has lived with me essentially his whole life.
Okay, that's what I meant to say. I apologize. I keep mixing
A lot
their
of a lot of D's and L's.
yeah. And what's the relationship like between the children and your mother?
They love my mother. They
Nice.
love my mother. The sun sets and rises on their nana.
And I assume that they spend some time with her and in that you're all living together.
Mm-hmm.
Yes.
Yes, sir.
Um, do the kids do you have other extended family that the kids see?
From time to time, my brother shows up. He works here in town, but lives in Kalamazoo now. So he stops by normally on Fridays, but I don't have much extended family in the area anymore.
And I think we talked about this, but you don't have any criminal convictions.
No, sir.
Are you aware of any uh, convictions that Miss Smith has?
No, sir.
What, if any, concerns do you have regarding um, Miss Smith exercising parenting time?
The concerns I have is that they should still be supervised visits. I would ask that they not be ever held anywhere near DeAndre Cole or with him in attendance.
Who is
Um,
Cool.
DeAndre Cole is the gentleman that you saw enter my home on the video.
And what is the reason that you don't think he should be around the children?
Um, the reason has to do with the fact that the situation that involved him and Saranda facilitating that situation by calling him over placed the entire household in danger. Anything could have happened. I could have showed up at the door just trying to see who was, coming through the door and got shot, or any of my children could have got shot. My children play on that porch quite regularly. It's not out of the realm of possibilities for them to be out there playing with toys on the porch. So the situation was dangerous, and that is a concern of mine, that they never be around anybody like that.
And I know you had indicated in response to my question regarding potential concerns regarding Ms. Smith, I know that you had indicated that you thought the visits should remain supervised. Could you provide specific concerns that you have rather than what you're looking for?
The specific concerns are that I don't believe that Saranda has the ability to parent the children effectively on her own. I believe that she needs a little help and supervision to make sure that it's going correctly, and to ensure that the children, while in her exercise parenting time, are in a location that is safe and conducive to happy and healthy children. Which is why I would ask that they would still remain supervised.
Are you aware of any CP involvement involving any other of Ms. Smith's children?
Yes.
And what was the nature of that?
I can't give you the entire story. I just know that her oldest was removed from her custody and placed with a foster family, and they ended up adopting him.
Prior to this incident with CPS and after all of the children started living with you in July of 2023, you were working with Ms. Smith to allow visitations, correct?
Yes.
And that was something that you were facilitating with her, and she was coming to your house to visit with the children?
Yes, sir.
And the reason that stopped happening was this incident with CPS, or that led to the CPS investigation?
Yes, sir.
But prior to that, you didn't have any issue facilitating those visits and trying to facilitate a relationship between Ms. Smith and the children?
Prior to that, no, sir, I did not have an issue with that.
Do any of the children have any special needs?
No, sir.
Are there any health concerns with any of the children?
No.
Thank you, Judge. That's all the questions I have.
Okay, thank you. Ms. Smith, do you have any questions of the defendant?
Yeah, actually, health issue wise, Devin Daniel claims that their kids have no health issues. Queen has asthma, doesn't she?
Ma'am, you can ask him questions. You can't make statements now.
Queen has asthma, doesn't she? And he took her to the doctors, and her doctors explained this to him.
Ms. Smith, okay.
That's kind of a question, isn't it? Like,
Yeah, it kind of is. Okay.
Because I'm asking if the doctors had stated to him how she has asthma or not. I don't know how to word that.
Go ahead, sir. You can answer.
No, her doctors have not explained to me that she has anything that resembles asthma. When we have gone for our regular checkup, she always comes back a very healthy child. If there was any concern of her having asthma, they would have told me so.
Only other question I think I can have in my head right now. Isn't it true that you stayed with me the whole time after Davion was born, pretty much for the first like 2.5, 3 months in my apartment with Junior?
No,
On and
no,
off
we
stayed
did.
with me.
No, we did not stay there. Yes, I did show up on and off to facilitate time with my son and to help you out, but no, we did not live there.
Isn't it true during the time of you seeing Queen in the last year that she had more marks on her?
Yes, it is true. And those marks were found to have not been what you claimed them to be.
Those marks were the same marks from the last case, but okay. I don't think I have very many more questions because I don't have a chance to talk to an attorney yet. I think that's gonna finish me up for my questions right now.
Okay. I do, sir, in this particular case, since you've had the kids now for over a year, has the plaintiff provided any financial assistance to you to care for the children?
No, sir. And currently she is past due on Devin Jr.'s child support.
Excuse me?
I said, and currently, sir, she is past due on Devin Jr.'s child support.
Okay, so there is a support order on Devin Jr.
There's a
Yes, sir.
motion in place for that.
Okay, ma'am, don't talk. You have an opportunity, I'll give you an opportunity to speak, but not during the questioning. Sir, after the incident that occurred in the video, which that would have been, I think you said on 3/12/2024, is that correct?
Yes, sir.
And after that occurred, you stated that you received Queen back approximately a day and a half later from CPS, correct?
Yes, sir.
During that day and a half, did the plaintiff ever contact you to basically arrange any time you could see Queen or have any contact with her during that day and a half?
No, sir.
I think you said with regard to Junior that you stated he's repeating kindergarten.
Yes,
And
sir.
I think you said, and I'll have to find it. Maybe you can answer because I'm not finding it right off. And why, okay. Why is he repeating kindergarten again?
He's just not emotionally ready to go to the first grade. When he started kindergarten, he was the youngest in his class. He had just turned 5 that September the 27th. And it's believed that he would benefit from spending an extra year in kindergarten.
Thank you.
Yes, sir.
You stated that you have a good relationship with the children.
Mm-hmm.
And as part of that, you talked about activities and stuff that you engage in. When you're with the children, do they exhibit signs of affection and love towards you?
Yes.
And how do they do that?
Davion, because he's just now learning to talk, he'll run up and he'll hold dad's legs and hug dad's legs. Queen still hugs my middle a lot. Junior likes to jump and run and play on dad. I'm a jungle gym apparently. Queen likes to kiss my side, or she'll kiss my forehead when she can get close enough for my cheek. Davion, he's just Davion. He's gonna be everywhere. He's gonna do everything, and he's gonna be in the middle of it all. So if they're all wrestling with dad, he's jumping in too.
And likewise, do you reciprocate and show love and affection towards them?
Yes, sir.
And how do you do that?
I do it in the most affectionate way possible. I wrestle with Junior a lot. I toss him around on my shoulders. Davion gets tickled. He doesn't like to be tossed around too much. Queen, she's a little girl, so I try to be gentle with her. We don't wrestle too much. We just hug and we'll cuddle up on the we'll cuddle up on the couch and we'll watch TV and things like that. But I'm still trying to learn how to how to how to take care of a little girl in all of her needs. She's definitely not one of the boys. She's her own person, and she definitely needs a special type of attention directed especially for her.
Okay. Anything else, sir, that you'd like me to be aware of?
No, sir.
Okay, thank you. Ms.
Yes, sir.
Smith, do you have any recross of the defendant?
There's a motion in place for Jevin Jr. right now. That is the only reason why payment has not been made for the child support on him right now, because the motion is in place. I do not know if he received anything in the mail yet from that, because it had just been recently sent in, but there is a motion that I have filed for Junior.
Okay, do you have a question of the defendant?
Not that I can think of at this time, Your Honor.
Okay. Mr. Hilderly, do you have any questions as a result of the court's questioning?
Just one follow-up, Your Honor.
Okay.
Mr. Daniel, with respect to Devin Jr. and the decision to repeat kindergarten, was that something that the school had input on?
The school had input on it. His grandmother had some input on it also, and looking at the progress that he made from the start of last year to the end of this year, yes, he made great leaps and bounds, but emotionally, he's just not ready for first grade.
Okay. Thank you, Judge. That's all I have.
Okay, thank you. Anything else that you have as a result of that question, Ms. Smith?
I do not have a question, just want to state that Junior might have dyslexia like his mother does.
Okay. Any other witnesses, Mr. Hilderly?
No, Your Honor.
Okay. Do you rest?
Yes, Your Honor.
Okay. Ms. Smith, do you have any rebuttal testimony or witnesses?
As of right now, no, I do not, Your Honor, because I do not have an attorney representing.
Okay. Looks like that concludes the testimony in this and evidence in this matter. So, Ms. Smith, you have a right to make a closing argument if you wish to do so.
Only closing argument I have is this male got with me when he was 30 years old and I was 17. So we've basically been on and off dealing with kids each other for a while now, and he's basically have used the kids over my head to be able to keep me around.
Anything else, ma'am?
Queen's been with me for the last 2 years until his dad decided to do this because child support was placed for Queen and Davion. That's also the only reason why he has the kids and had them for a year, because he took them out of the home when child support was placed for Queen and Davion within 2 days after that.
Okay, thank you. Anything else before we turn it over to Mr. Hilderly?
No, that'd be all.
Okay, Mr. Hilderly, closing.
Thank you, Your Honor. I think initially, based upon the testimony that the established custodial environment rests with Mr. Daniel, the testimony is such that the children have been living with him exclusively for more than a year now. There has been an appreciable amount of time that the children look to him for care, and we do believe that the established custodial environment rests with Mr. Daniel. An examination of the child custody factors certainly would favor Mr. Daniel and would reflect that the best interests of the children would be served if they continued in his care. As previously stated, he's provided care for them solely and exclusively for more than a year now. He's been solely responsible for their care, doctor's appointments, dentist appointments, school, arranging daycare, getting them enrolled and making sure they're in school and everything is appropriate in that regard. He's provided them with a stable living arrangement for the past year, as can be seen in the photographs that were provided. They were not being provided with a safe and appropriate environment while in plaintiff's care. I think it's for those of us who have children, we know, I think it's a little silly that plaintiff claims that this is motivated because of child support. I think what most parents would know that it's certainly far more expensive to have the children in your care 100% of the time and provide for them, provide everything that they need, than it would be to just pay child support each month. So certainly I expect that it's been much more expensive for Mr. Daniel over this past year plus, having them and providing for them solely the past year than it would have been for him to pay child support. I didn't get the impression at all that this is financially motivated, was motivated by a desire to remove his children from an unsafe and inappropriate environment. He's done that. He's provided care for them in an appropriate place to live. Just going through, based upon the information the court has before it and the testimony that's been provided, certainly the love and affection and other emotional ties would favor my client. He testified about the relationship that he has with the children, the way they show affection with each other. We had no information or testimony regarding that factor regarding the plaintiff. As far as capacity and disposition of the parties involved to give the child love, affection, and guidance, my client testified that he has been providing sole care for more than a year, getting them ready for bed, preparing meals, taking them to doctors and dentist appointments, getting them to and from school and daycare. My client testified that he is employed and has been financially providing for the children. We had no testimony from plaintiff regarding employment or her ability to financially provide. Testimony is that she has not provided any financial support over the last year and is behind on a current support obligation. I think that the children, certainly with regard to Devin Jr., having lived with Mr. Daniel for his entire life, has lived in a stable and satisfactory environment, and the other children for more than a year now. Certainly it would be beneficial to children to maintain that continuity. They've certainly been with Mr. Daniel long enough that's the environment they're to and would be best to serve their best interest. They do have a close relationship with Mr. Daniel's mother. She does live with them, provides some care as well, and it sounds like participates in their care and guidance as well. My client testified that he doesn't have any criminal convictions. Further, he doesn't have any mental or physical disabilities. The homeschool and community record of the children, they're still pretty young. Mr. Daniel did provide some testimony about Devin Jr. in school and how Mr. Daniels participated in that. Has Devin Jr. enrolled in school, and Queen is in a good preschool program. So it doesn't sound like there's much in that regard in terms of the homeschool and community record. Children are probably a little too young to express a reasonable preference, but obviously that's up to the court. If Devin Jr., if the court feels Devin Jr. is maybe old enough at this point, that would certainly be up to the court to decide. I think Mr. Daniel, having the plaintiff come over and participate in parenting time and helping to foster and facilitate that relationship, certainly that factor is reflective positively on Mr. Daniel and should favor him. No testimony that domestic violence is a factor in this case. So certainly we think that an evaluation of the child custody factors favors Mr. Daniel and would support the court's decision to award him sole legal and physical custody of the children. He's already been doing all of that with regards to medical decisions and making sure they're seeing doctors and dentists and also facilitating their school. So we would ask the court to grant Mr. Daniel sole legal and physical custody of the children, and that we continue with supervised visits for Ms. Smith at this time. Thank you.
Thank you. Ms. Smith, any further closing argument?
I would just request to have unsupervised visitations with my kids overnight. Seems I did have my daughter for 2 years, took care of her on my own for 2 years, just fine, along with Davion, until up to this point where he took them.
Okay, thank you. Well, in this case, as the attorney knows, the court again has to decide custody based upon the Child Custody Act at MCL 722.21 at SEC, specifically 722.23. But first, in any case, the court has to determine, again, if there is an established custodial environment. An established custodial environment exists if over an appreciable time the child or children naturally look to the custodian in that environment for guidance, discipline, necessities of life, and parental comfort. The statute provides that the age of the child, the physical environment, and the inclination of the custodian and the child as to the permanency of the relationship shall also be considered. In this particular case, the testimony has been different as to the different children. We have 3 children involved. We have Devin, we have Queen and Davion. And in this matter, I'm going to have to address those separately because the time frames and all of that are a little bit different. In this particular case, I guess I'll say Devin, who I'll refer to as Junior because he's been referred that way throughout the trial in this particular matter, that Junior has apparently, based upon the testimony, been in the care of the defendant almost his entire life. And the difference is the other 2 children have been in the care of the defendant since July of 2023. So things will be a little different, but it does appear when we look at that as far as providing guidance, discipline, necessities of life, and parental comfort, that the defendant testified as to parental comfort, as to the love, affection, and that he gives to the children. He's talked about the guidance, that there's not been any really testimony about discipline, but there's also been testimony about the necessities of life, that he's been providing those for the children entirely since the July 2023 date and for Junior prior to that time. When the court looks at, again, all of the evidence and testimony presented, it does appear to the court that the established custodial environment is clearly with the defendant father. The court then has to look at the best interests of the children The first factor under the best interest test is the love, affection, and other emotional ties existing between the parties involved and the children. In this case, the defendant has testified as to that love, affection, and emotional ties. He testified that, again, with Junior, it's more physical. They wrestle. They have more physical contact. With Queen, that in fact, he talked about how she will cuddle with him, give him hugs, give him kisses. Same thing with Davion, that he will give kisses and hugs, etc. And there's been little testimony in that regard of that situation involving the plaintiff. So the court will find that this factor does favor defendant father. Next factor is the capacity and disposition of the parties involved to give the children love, affection, guidance, and continuation in the education and raising them in a particular religion or creed. The defendant had testified that, again, the children they've been to church apparently with his mother, but they have not really involved much in church, and the plaintiff did not testify as to any of that, so the court will not consider that aspect. But again, the capacity and disposition of the parties to provide love, affection, guidance, we've heard that from the testimony of the defendant and his capacity and disposition to do so. Those are two different things. We've not heard any testimony from the plaintiff as it related to this factor, so the court will find that this factor does slightly favor the defendant father. Next factor is the capacity and disposition of the parties involved to provide the children with food, clothing, medical care, and other remedial care recognized or permitted under the laws of the state in place of medical care and other material needs. In this case, the defendant testified that he'd been providing for all of those material needs for Junior throughout his life, that he has been providing for those needs of Queen and Davion since he's had the children in his care, that he's been solely financially responsible for, again, the children, and that the plaintiff has not provided any financial assistance during this period of time in excess of a year. And in fact, he had testified that she is behind in the support obligation that she has with regard to apparently a support order with regard to Junior, and that she is behind in that. She had stated that apparently there's been a motion filed in some regards, but again, that would again imply that she did not dispute that. And so the court will find that this factor does favor defendant father. Next factor is the length of time that children have lived in a stable, satisfactory environment and desirability of maintaining continuity. As stated, Junior has been with the defendant his entire life, and the other children just over a year. In this case, they're in a stable, satisfactory environment with the defendant. That there has in fact been no testimony that they are not in a stable, satisfactory environment. It appears that based upon what the defendant testified, that they have a routine when they're in the home, and that is being followed. And as a result, the court will find that this factor does favor defendant father. Next factor is the permanency of the family unit, the existing or proposed custodial home or homes. The defendant had testified that he's lived in the home with his mother for approximately 3 years. We've not heard any, well, again, that will relate to the last factor, the stable, satisfactory environment. As it relates to the permanency of the family unit, there's been really no testimony other than, again, that the environment of the defendant has been stable. There's not been any testimony that it is in fact not stable, that there's any particular changes coming in this matter. The court doesn't know because the plaintiff did not testify as to any of these particular factors. And as a result, based upon that, the court will give a slight advantage to the defendant in this matter. Next factor is the moral fitness of the parties. There's not been much in the way of moral fitness. There's been testimony that the defendant does not have any criminal history. He testified he didn't believe that the plaintiff had any criminal history as well. And there's not been any other testimony or evidence given concerning any other, I guess you'd say, the factors or circumstances that would impact the moral fitness. The court's going to find this factor to weigh equally as to both parties. Next factor is the mental and physical health of the parties involved. The defendant testified that he does not have any mental or physical health that is problematic in this particular matter. He testified he's not aware of any criminal health or criminal concerns with the plaintiff as well. And so, as I stated in this matter, the court will find that those factors are equal as to the moral fitness. As to the mental and physical health, again, he testified he has no mental or physical health issues. He did not testify that the plaintiff has any mental or physical health issues that would impair her ability to care for the children. As a result, the court will find that this factor is equal as to both parties. Next factor is the homeschooling community record of the children. In this matter, the testimony has been that Junior is in school, that he and the other children are in daycare, that there's really no community record in this matter. This school record as it relates to Junior is the only thing that's applicable. He was in kindergarten last year. He's repeating kindergarten because last year he was an early or a young 5, and the defendant testified that in conjunction with the school and that he did decide that it was best to have him return to kindergarten, notwithstanding the fact that he made substantial progress over the year as it related to his education. Again, he testified as to the home environment and the home record, and that does appear to, again, be favorable in the defendant's home. The court's going to weigh this factor in favor of the defendant father. Next factor is the reasonable preference of the children. The court, the only one that would possibly be interviewed would be Junior. The court doesn't believe that that is necessary in this matter, because as I weigh the factors, the court will show that, again, they're pretty overwhelming in favor of the defendant in this matter. And again, at the time that the case was originally filed, he was very young, and the court therefore not consider this factor in this case. Next factor is the willingness and ability of each of the parents to facilitate and encourage a close and continued parent-child relationship between the child and the other parent. In this case, the court would note that prior to the plaintiff receiving her supervised parenting time, that she had in fact had parenting time in the home of the defendant and his mother. And however, after the issues with her taking and absconding with Queen, that he didn't feel safe or did not feel that it was appropriate to have her in his home. And as a result, that was again eliminated, and she had the parenting time through the with CPS involved, and she had that quite regularly, although the defendant had testified that Aria Smith, who was the person that facilitated and was the supervisor, she had issues concerning some health issues, issues concerning her schooling, and she was not regular. But as the plaintiff testified, she had approximately, in that last year, she had 10 to 12 supervised visits with the children. The court notes that, and I will address this under other factors as well, but the court notes that on March 12, 2024, that the plaintiff appeared at the defendant's home to exercise the parenting time, and there was a knock at the door that the defendant answered that, thought it was his mother who was not there. It apparently was the plaintiff's significant other and another individual. And we saw the video in this matter, and in fact saw that, again, there were statements made to the extent that one of the individuals may have had a gun. And at that point, the plaintiff raced out of the home with the child as the child was screaming. The court does not believe that, again, that's appropriate. And in fact, court will state that that kind of conduct by a parent is reprehensible. And in fact, obviously based upon Queen's response, she was terrified. She, again, was put in a position where she could have sustained some sort of injury or had something occur to her in this matter. And therefore, considering the matter under the other factors, the court under factor L, the court finds that factor to weigh strongly in favor of the defendant father. Getting back to the willingness and ability to facilitate, the court did ask and question the plaintiff as to, and the defendant as to whether she had reached out to him at all when she had Queen in her care for the day and a half. That was a minimal time, so I can't read too much into that, but she did not attempt to make contact with him, to have any contact with the child. The court will find that this factor does slightly favor the defendant father. Next factor is domestic violence, regardless of whether violence was directed against or witnessed by the child. There's not been any testimony about domestic violence other than this incident occurred on March 12, 2024, where the court could infer that, in fact, this ruse that occurred with a potential to have a gun involved could be domestic violence, but the court's not giving it much weight in this particular matter. When the court weighs these factors for the plaintiff to prevail and to acquire custody under the Child Custody Act, where the court has found that the established custodial environment is with the defendant, she must prove by clear and convincing evidence that it is in the best interest of the minor children that they be in her care. The court finds, based upon a review of all the factors, and I don't weigh those like baseball box scores where we simply add them up and say one way or the other, court find and will note that appellate courts have stated the court has the discretion to give more weight to some factors over another, and can consider other factors as well, which the court has done. And I find that the proof presented by the plaintiff in this matter does not even raise to a preponderance of evidence. And in fact, the court finds that the defendant has established by overwhelming, clear and convincing evidence that it is in the best interest of the children that the children remain in his care and custody. And as a result, the court will so order. Next, the court has to look at parenting time in this particular matter. And parenting time is governed by MCL 722.27A, and the factors under, again, the factors that the court has to look at in this matter, and I'll go through those factors as well. The first is special circumstances or needs of the child. The defendant has testified the children do not have any special circumstances or needs. The court will not consider that. Next is whether a child less than 1 year age and is nursing. That is not applicable in this case as well. Other factor, likelihood of abuse or neglect of a child during parenting time. The court is troubled somewhat by the pictures the court saw as Defendant's Exhibit A, showing the house of the plaintiff in this matter being obviously unkept, disheveled, and dirty. So the court is taking that into consideration in this matter. Next is the likelihood of abuse of a parent during the exercise of parenting time. There's been no testimony about that. Next, the inconvenience or burdensome impact of travel on the child. Parties both live in the Battle Creek area. There's no problem as it relates to travel. Next factor is whether a parent will reasonably be expected to exercise ordered parenting time. The plaintiff has exercised her parenting time in this matter, and although not ordered, she has done so. So the court will, in fact, assume and presume that she will do that in the future. Next factor is whether a parent frequently failed to exercise parenting time. There's not been any testimony about that. The next factor is the threatened or actual detention of the child. Clearly, the incident occurred on March 12, 2024, with the plaintiff absconding with Queen and not returning her until services were involved. Clearly, there was threatened or actual detention of the child, and the court will take that into consideration. Next is any other relevant factors in this matter. Obviously, there's been substantial factors in this regard as it relates to the parenting time that and the CPS involvement that again, they were to a point where a safety plan was instituted. The plaintiff states that the safety plan has now been ended once the CPS closed their case, and that may be. But in this particular case, as of last week, CPS was still involved in providing supervised parenting time for the plaintiff. When I weigh these factors as well as the best interest factors in this case, the court does believe at the current time that it is appropriate to continue the supervised parenting time. And that parenting time will be continued to be supervised by, I guess you'd say, someone under the guidance of Child Protective Services. If in fact the case is ended as plaintiff states, then there's going to be a need for an additional or a different supervisor for the parenting time. The court will allow that to occur. And with the defendant providing a list of 3 potential supervisors and providing that to the plaintiff, and then she'll have a right to, he'll provide that to her at the point that CPS is not involved, and that she'll have 7 days from being provided that list to designate a supervisor in this matter. If she rejects all of the particular supervisors, then she'll have to petition the court to have, again, the court review that matter further. Court will note we actually did not receive any testimony as it relates to the income of the parties. We had testimony from the defendant as to him working at T-Mobile, and there's been no other testimony. So I guess at this point, court should be an order in place as it relates to Junior. As to the other children, I guess I'll have to leave that to Mr. Hilderly. You're going to have to file a motion and provide evidence as it relates to the incomes of the parties in this matter, because there was no testimony about that in the case today. And therefore, the court is not capable of making a determination as to that support obligation at the current time. Court will note, as I reviewed and prepped the file in this matter, court will note that the plaintiff has still failed to pay her mediation fees in this matter to Chris Arnett. As a result, the court will ask Mr. Hilder, you put a provision in the judgment that would order that she would pay that sum of money within 30 days of today's date. And upon failing to do so, that Ms. Arnett could in fact proceed with enforcement action against her in this particular case. I'll ask Ms. Smith, that is the full ruling to the court. Is there anything else that you believe the court needs to address or has failed to address before we conclude today?
They failed to address any environment the kids are in with Devin Daniel right now, and the bruises and marks she's been left on her by him.
Well, ma'am, what happens is that's why we have that's why we produce evidence, have a trial for parties to produce that. You did not produce any evidence as it relates to any of that. And as a result, the court can't consider it if you don't produce that.
I submitted evidence through Gmail just like he did when I got the evidence that he had sent. That's makes no sense why my evidence wasn't getting brought up in court.
Well, because you didn't bring it before the court, ma'am. Just
I sent it through Gmail.
because you file something does not bring it before the court. That's why we have a trial. At trial, you have a right to produce. I asked you repeatedly. I asked you to produce any witnesses, to produce any evidence. You failed to do so. And as a result, when you fail to do so, the court cannot take into consideration something that you filed that you do not seek to introduce.
So I did. His attorney did not present my evidence.
Okay. Well, his attorney is not required to produce your evidence.
That's what I was told to do, was present my evidence to him because I don't have an attorney and not allowed to have an attorney on this case.
Okay. Mr. Hilderly, is there anything else that you believe the court has failed to address or needs to address before we conclude?
Just wanted to clarify, when on the custody ruling, I understood it would be physical custody with Mr. Daniel. What did the court make a determination as to legal custody?
The court will do say, I didn't specifically break that down. I usually, if I don't designate, then it's to include legal and physical custody. In this particular matter, when the court does legal custody, and the parties are entitled to, again, be aware that the parties can proceed with joint custody. And the plaintiff obviously knew that because she had testified, or when she had given her opening, she stated she either wanted custody or wanted joint custody in this matter. The parties are entitled to have joint legal custody if in fact they are generally able to agree on important decisions affecting, again, the welfare of the children. There's not been any testimony about the ability to for the parties to cooperate and come to an agreement as it relates to those particular factors. In fact, as I note on the instance that occurred back in March 12, 2024, court does not believe that again is, I guess you say, representative of the parties being able to agree as to important decisions affecting the children. In this case, the defendant also testified that he's been solely responsible for the last year plus for approximately 13 months for the children. He's been making all of the decisions as it relates to medical care, as it relates to schooling, as it relates to daycare, etc. And as a result, the court will award to the defendant the sole legal custody as well. With that, Mr. Hilderly, is there anything else?
No, Your Honor. Thank you.
Okay. Now give last opportunity, Ms. Smith, anything else that you have before we conclude?
Nope.
Okay. Thank you, Mr. Hilderly. You can submit that judgment and submit that to the front of the court for approval. And then once we have the approval, the court will enter that. And I want to wish everybody the best. I hope everything works out, and I hope things are able to move ahead. And you're free to go. Have a wonderful day.
Thank you for
Thank
your
you, sir.
time.
Let's get the facts straight. She loves a verbal ashtray. Never blowing smoke when she gets pissed. She's quick to castrate. Love her on a good day, love her on a bad day. Either way, she's here to stay, stay, stay. Call up holy, 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 holy.